Hello and welcome. It's Jackie Broman here, and today I'm going to be talking about trusts in your will, particularly protective trusts for vulnerable beneficiaries and what you can do for them in your will. In each family, there's often a financially irresponsible child, but when it goes one step further and that child is a gambler or has a drug or alcohol problem, you'll probably want to make sure that your child does not squander your hard-earned estate when they inherit it. Cutting them out of the will is not an option because with their needs, they are likely to have a really strong claim in contesting your will. So there are a couple of different trusts that you should consider. The first is a protective trust. Now, this was legislated in the 50s in Victoria, so you don't need an extensive trust deed attached to your will. They're a bit of an old-fashioned trust. How it works is that you leave your inheritance to your wayward child in a protective trust. Only the income earned on their inheritance can be paid to them. The whole of the capital is protected. It prevents the wayward child from spending the capital sum. After your wayward child dies, the capital part of the inheritance can be passed to someone else of your choosing, maybe onto your grandchildren or onto another of your children. These were set up a lot in the 50s and 60s, but there were many of them that were contested and set aside, so the child ended up with their inheritance anyway. And there are other problems of trying to forfeit the interest in the protective trust, and when the protective trust ends, if not on the death of a child. There's also the issue that any income from the protective trust can still be available to your child's creditors. So if they're a gambler or they become bankrupt, the capital, while it's protected, the income is not, and the creditors can take it every time it's issued from the trust. Another couple of trusts that exist are a minor's trust. Now, if your children are under the age of 18 when you die, their inheritance is automatically held in a minor's trust until they're 18 years old. However, you can extend the age of a minor's trust to say 21, 25, or even 30 or 40, when you hope that your wayward child has grown out of their irresponsible ways. Someone else will be in control of their inheritance until they reach that age, and their inheritance can only be used at the discretion of that trustee. Excuse me. But this offers little protection if they have not changed their ways by the time they reach your specified age. They'll inherit everything absolutely once they reach that age, no matter how their behaviour has changed. So another option, which might be the better option, is a discretionary trust, which is often just called a testamentary trust. A family trust where the vulnerable beneficiary is not the only beneficiary and has no control, and any distribution to them is at the complete discretion of an independent trustee. Or the trustee could be a group of your other children, or the vulnerable beneficiary could also be made one of a number of directors or trustees, but any decision made has to be by majority or a unanimous agreement. A discretionary trust deals with the issue of the wayward child having control. It also overcomes all the protection issues for the capital and for the income. The wayward child's interest in the trust is not worth anything, so they can't sell the value of it, and it's not available to creditors. So if your child has any of these issues, the solution is not to leave them out of your will, but to work out a way of protecting them and your hard-earned estate. You need to think about your objectives for your estate and how it would be best inherited by your children and which trust achieves the best result. So I'm the principal solicitor at TBA Law. Our offices are at Nagambie and Wallen, and I'm also available in Burke Street in Melbourne by appointment. So you can contact us by phone or email to ask some questions and set up an appointment if you'd like to find out more.